Hi there, thanks for joining us. In this video, we're going to be talking about your appeal options if your Canadian study permit or work permit application has been refused. If you've applied for Canadian work permit or Canadian study permit and your application was refused, what are your options? Can you appeal that decision? We'll have the answer to these questions after the break. As always, remember to like our videos so that others will see more videos like this. Subscribe to our channel so that you'll be notified the next time we publish a video. And check us out on our website at go.gooselaw.com. We'll be right back. Welcome back. My name is Donovan Francis and I'm a Canadian immigration lawyer, and I assist businesses, families and students with their Canadian immigration matters and save them from dealing with complicated immigration rules. In this video, I want to talk to persons who have submitted a temporary residency application to Canada and whose application has been refused. Now, when we say temporary residency, we're talking about specifically either application for a visitor visa, an application for a study permit, or an application for a work permit. Persons who've submitted any of these applications, if your application is refused, you do not have an automatic right to appeal it, to challenge it. Okay? So some applicants, some persons applying for permanent residency, for example, have a right of appeal, meaning if their application is refused, they automatically get the opportunity to challenge that decision. This is not the case for persons who've applied for a study permit, a work permit, or a regular visa. You do not have a right to appeal. So what are your options? Firstly, if there's a refusal, you want to understand the reason for the refusal, and then you want to challenge that decision or submit a new application based on the reasons. Okay, so option number one is to submit a new application that addresses the concerns that would have been raised by the officer who refused the application. But that is not always the most effective route. There are situations in which it may suit you to actually challenge the decision in Canada's federal court. And your option for doing so is known as the judicial review option, JR, judicial review. Judicial review is available to persons who submitted temporary residency applications that have been refused. However, getting a judicial review is not something that's automatic, okay? You first have to apply to the courts for permission to get the decision reviewed, judicially reviewed, okay? And this permission is referred to as seeking leave. So you have to seek leave to have the immigration officer's decision overturned in a judicial review. Now, timing is critical for judicial reviews. If you are or were in Canada, if you submitted your application inside Canada and that application was refused, then you have 15 days after the official refusal date, or the official date on which you were notified of the refusal. You have 15 days within which to submit an application seeking leave for judicial review. If you were outside of Canada, however, when you submitted this application that was eventually refused, then you will have 60 days, 60 days within which to submit your application seeking leave to challenge the decision in the form of a judicial review. Now, we say an application seeking leave because leave does not have to be granted. The courts are not obligated to grant you permission to have your judicial review heard. And so we typically only recommend judicial review where the application that was refused was actually very strong and the officer made very glaring errors in refusing the application. So in those kinds of situations, we recommend a judicial review. But again, you first have to apply seeking leave for judicial review. If leave is granted, then your application goes on to an oral hearing in front of the courts. Okay, so that's going to be the option available to you if your application has been refused. Now, if at the judicial review stage, the judge agrees that there were glaring errors in the decision made by the Canadian immigration officer, then the judge will likely refer the file back for reconsideration by the immigration authorities, and that reconsideration obviously would be by a different officer. But the officer's decision would have been overturned. It's also important to note that there are also, when you submit an application seeking leave for judicial review, the government side, so the lawyers on the government side, will be reviewing the documents that are submitted to see whether or not your case is a strong case. And if your case is a really strong case, then it is possible that they may want to arrive at a settlement rather than having the case go through to hearing. And then when it goes through to hearing, then the judge would rule in your favor, creating what's called a precedent, that could then be used by future applications in a similar vein. And so the lawyers on the government side, if your case is strong, may not want your case to go through to judicial review and may instead agree to some kind of a settlement whereby your case will be referred for reconsideration without having to actually go to an actual hearing. Okay, so that's one thing to bear in mind. Another thing that we advise our clients about before submitting this application is that when you submit an application for judicial review, you are not able to introduce new evidence at that point. Okay, so the judicial review only takes into consideration all of the supporting documentation and facts that you would have included in your initial application, which had been refused. And so we therefore have to go through the application and make sure that that application was strong and that it had all of the necessary supporting documentation. And once we're convinced, we're satisfied that that was the case, then we advise that you proceed to judicial review. But importantly, do bear in mind that you cannot introduce new evidence at the judicial review stage, okay? That's a crucial factor to bear in mind. Lastly, in the event that your application for judicial review is refused, then there is no right to appeal that at the appeal courts, the federal appeal courts. And the only way that that decision can be challenged is if the judge indicates that there's a certified question, that there's an issue that was left unresolved and that which would be best heard by an appeal court. But outside of that, a decision to not grant a judicial review cannot be challenged at an appeal court inside Canada. So I trust you got value from this. If you have applied for a study permit or a work permit or a visa and it was refused and you are wanting to know about your appeal options, then you do not have an automatic right to appeal, but you may apply for a judicial review to have that decision overturned and have your application reconsidered. Okay, I trust you found value from this video. As always, remember to like our videos so other people may see more videos like this. Subscribe to our channel so that you'll be notified the next time we publish a video. And check us out on our website at go.gooselaw.com. Thanks, see you again.